For hearing, item 1 to 10 and 16.
Yes. Yes, item 1.
1 to 10.
Lord, my item is 3, my lord.
My item is 4.
Mr. Chaudhary is not appearing in item 1.
No, but item 1, I'll be appearing along with my friend K. Devi. But my lord, I'm in item number otherwise, Kiman? 44 and 62. End of the day, the ground of challenge possibly may be more or less same. I understand when Honorable Chief Justice Julia was there, some groups were made, A, B, C, D. So accordingly, we prepared our written argument and we submitted also. And that was heard at some length also because his lordship's left. Groups were made, A, B, C, D. And in fact, I appear in group B and E, B and Kibata. No. Julia did. My argument is-
Judicial order.
There's a judicial order also.
What is the date of the order?
I think lordship was also a part of the bench.
Order dated 25/7/2023. Lordship and the same bench. The same bench.
25/7/2000.
23. 25/7/2023.
All these writ petitions have been bunched together and listed before this specially considered division bench for final hearing and disposal. However, during the course of argument advanced by the parties, it transpired that writ petitioners deal with slightly different issues requiring different nature of consideration and adjudication. And therefore, it may not be permissible to dispose of the writ petitions by a common order. In other words, it appears that these writ petitions, although pertaining to provincialization of the services of school teachers, the projections and dimensions of the contentious issues in a number of writ petitions are different from one another. As such, unless writ petitions are further classified on the basis of the subject matter of dispute, as well as nature of relief prayed for, it may not be possible for this court to embark upon an adjudicatory exercise in these matters. In view of registry, we examine the aforesaid aspect of the matter and group these cases under the
Broad subheadings.
broad subheadings. On the basis of the inputs to be furnished by R. Mojumdar Learned Standing Council, School Education Department. It would be open for the registry to accept suggestion and inputs from the Learned Council for the respective parties in this regard before finalizing the regrouping of the cases within the broad subheading. Once the aforesaid exercise is carried out and completed, these matters will be listed again under the with appropriate subheading for hearing.
All right, now items 1 to 11 has the subheading is challenge to section 2U.
I think
Four
that
to-
exercise has been carried out.
Yes, it is mentioned in the call.
Yes, I think that it has been done.
So let us proceed. Yes, items 1 to 11 and 20 and 83. Sorry, 1 to 10 and 83. Where is 80? 83 to 9? Right. Yes.
I'm in item two, lordships. Additional written submission.
Items 1 to 10 and 83. Yes, please.
May I just copy the photocopy here? May I just hand this over for the convenience of the court?
Yes, yes.
We had made a. Now, as lordships have seen in the last order, the writ petitions are for different categories. Now, I am appearing in this matter, Noor Islam and 51 others versus State of Assam. This is pertaining to music teachers.
Yes.
Yes. Before I go into my legal submissions, would lordship kindly appreciate the facts of the case?
Yes.
Lordship will appreciate our case from the perspective that I am only appearing for the music teachers, not for anyone else.
Yes.
Music teachers who are still to be provincialized. Item 2, Noor Islam. Now, facts, the petitioners are music teachers working in different high schools, high madrasa across Assam. They have been appointed on various dates here, starting from 1994 to 1995, till about 2005. They are both eligible and qualified for their services to be provincialized as per the provisions of the Assam Education Provincialized Services Act 2011, which has since been struck down. Now, this writ petition challenges the constitutional validity of Section 2U, 42, 6, 7, and 24 of the Assam Education Provincialization of Service Reorganization Education Act 2017. If lordship will see, the prayer is at clause 45, page 45. If
Yes.
lordship will kindly see our prayer, which is at page 45 of the writ petition.
Yes.
A declaration to be issued to the effect that impugned provision as contained in 2U, section 42, Roman 4, 6, 7, and 24 of the Assam Act of 2007 of the Assam Education Provincialization of Services and Reorganization of Educational Institutions Act 2017 are unconstitutional. A writ in the nature of certiorari to set aside and or quash the impugned provisions as contained in the similar sections. A writ in the nature of mandamus, directing the respondents to cancel, resign, and or forbear
So
from.
you have challenged this provision.
Yes, we have challenged it.
Let's come. Yes.
Now, please come back to my submissions.
Yes.
Now, would first lordships come to, as I at the very outset said, we are both eligible and suitable in terms of the previous act. And why we are claiming that we need to be provincialized, it starts from here. Please come to page 75 of my writ petition.
No, Mr. Goswami.
Yes.
Just to clarify one thing.
Yes, lordship.
These batch of writ petitions, various provisions of the act is under challenge.
Yes, lordships.
So we are not getting into individual facts. If the provisions are struck down, then the writ petitions will be allowed. If there are
Yes,
not,
but
then
the lordship may have to go into facts if we have to demonstrate that we had created a vested right amongst us in terms of the previous act, and that everything was done for me prior. The only thing that remained between our provincialization and not was the order of the division bench quashing the act.
No, that's right.
So
but
therefore,
are you not challenging the virus of these provisions?
we
Virus
are.
of the act.
We are, but the basis of challenge is why I'm lordship drawing attention to the documents that we had created, our right had crystallized, but for the act being quashed, our services would also have been provincialized. Everything was done. The final recommendation was also sent by the district committee. It is just that between the scrutiny committee's report recommending our names and the final order came this DB order quashing that. So therefore, lordship will have to examine then what is the import of that whole procedure? Does it vanish in thin air?
No, Mr. Goswami, you're trying to appreciate your argument.
Lordships.
You are saying that if the division bench would not have quashed the earlier act, your clients' services would have been provincialized.
Right.
So therefore, after the act was quashed, the new act comes in, which now blocks provincialization bid on the part of your clients. The sum and substance of your argument is this, correct?
I would just add to that.
All right.
After the division bench order came, the state filed a review.
Yes.
And in the review, the prayer made on behalf of the state is that please make this judgment prospective. Because in the meantime, 42,000 odd people had been actually provincialized.
Correct.
I'll take to that observation what they exactly did. The review bench did not make the judgment prospective. But at the same time gave them an olive branch that whenever you come with a new act, you can take care of these people, this 42,000 people who were provincialized, until such time they continue to be government servants and they will not be disturbed. Now, our question is, at that point of time, when they came in for review, the state was perhaps not very fair in just limiting the relief to those 42,000 people because everybody stood on the same footing.
So that's why, Mr. Goswami, we wanted to ask you that means your clients are basically aggrieved by the previous judgment of the division bench.
We are not. We are not aggrieved. We are, yes, the quashing of the act, obviously everybody is aggrieved because if the act would not have been quashed, we would have all got provincialized.
So therefore, your basic grievance is the quashing of the act.
In one way, yes, lordships, and also certain provisions that curtail our rights within this act.
All right. Now, insofar as your arguments regarding curtailment of your rights under this act, that we will examine. But if you premise it on the basis that the earlier act was illegally or erroneously struck down, that aspect cannot be gone into.
No, that is closed. That is closed. But the question is, have we been dealt fairly? The question is not of striking down of the act. The question is when there are two classes that are exactly similarly placed, have we been fairly treated? Is the whole question.
Fairly treated under this act.
Fairly treated under this act, fairly treated by government action. And if there is no fault on us, should we suffer the consequences? When a right, absolute right had been crystallized, can you take it back retrospectively? Therefore, if Lordship will kindly have a look at those documents. Please, Lordship, come to page 75.
Yes.
Now, this is a notification issued under notification under section 14 of the 2011 Act. Now, I may say that there was initially no qualifications per se laid down with respect to recruitment of a music teacher. So there was some discussion at the state level that what actually should be the qualifications with respect to music teacher. Now, what the notification says, and this is a notification under section 14 of the previous Act. May I just place it?
Yes.
Whereas this is dated 20th July 2014, whereas representation from various teachers association and individuals in respect of music teachers have been received, and that there was no prescribed qualification for the post of music teachers in venture higher secondary and high school at the time of their appointment. And whereas the post of music teachers were filled up in provincialized higher secondary and high schools in the year 1994, from amongst the candidates having minimum qualification of HSLC passed and Bisarat B music from any recognized university, college, etc. And whereas the government is satisfied that the qualification prescribed for the post of music teachers in the provincialized higher secondary and high schools during the period prior to 1/1/2006 may be taken into account for the same in the venture higher secondary and high school. Now, therefore, in exercise of powers conferred by section 14 of the Assam Venture Education Institutions Provincialization of Services Act 2011, the qualifications for the post of music teachers appointed in Venture Higher Secondary School and High School shall be HSLC passed and Bisharat B Music from any recognized university, board, college, etc. Take it from me, lordships, that we have these qualifications. And this was reiterated in a subsequent order, which order, lordship, which order is at page 76, the next page. Despite this, the government went on further consultation. Let us be sure about where we stand. This is also another notification under section 14. This is dated 15 February 2016. Whereas representation from various teachers association and individuals in respect of music teachers have been received, and there was no prescribed qualification for the post of music teachers in Venture Higher Secondary and high schools at the time of appointment, and whereas the post of music teachers were filled up in provincialized higher secondary and high schools in the year 1994 from amongst the candidates having minimum qualification of HSLC passed and Bisharat from Bhatkande B Music from any recognized university, college, etc. And whereas the matter was consulted with the judicial, cultural, and personal department, and the judicial department opined to the effect that there is no bar in accepting degree or diploma of the Bhatkande Sangeet Vidyapith for the purposes of appointment of music teacher in Assam, the cultural department also held the Sangeet Bisharat of the Bhatkande Sangeet Vidyapith to be equivalent to B Music of recognized university. The personal department furnished a no objection to provincialization of the music teachers as proposed. And whereas the government is satisfied that the qualification of HSLC passed and Sangeet Bisharat from Bhatkande Sangeet Vidyapith prescribed for the post of music teachers in recognized higher secondary and high schools during the period prior to 1/1/2006 may be taken into account for the purpose of provincialization of the services. Now, therefore, in exercise of powers conferred by Section 14 of the Assam Venture Education Institutions Provincialization of Services 2011, the qualification of HSLC pass and Sangeet Bisharat from Bhatkande Sangeet Vidyapith for the post of music teachers of recognized higher secondary and high schools appointed prior to 1/1/2006 shall be accepted as a very special case on a one-time basis for the purpose of provincialization of the services under the aforesaid act. So the difference between these two notifications is this. May I just point out? In the first notification, they just said, let it be a Bisharat. In the second notification, they specified that it has to be from Bhatkande. That is the difference between the two notifications. Now, this is followed by two things. In fact, prior to this, there are two documents which lordships is not on record. I'm very sorry about it. We should have put it on record. If I may just hand it over, the two important documents, lordships. Kindly have a look at this. This is an order of 22/9/2014. I'm sorry, one Xerox is not too clear. Now, this notification, I may just candidly say that this notification is with respect to the petitioner number 1. This is the school where he is presently teaching. Now, please see, the school has been provincialized. Except for the music teacher. Similar orders have been passed in respect of the other schools where the petitioners are working.
School has been provincialized means under which act?
2011.
That act dealt with provincialization of schools or provincialization of post of teachers?
Both. Ventures, educational institution and the employees. I'll take lordship to the act. If I may just place it in, this order is of 22/9/2014. We are eligible. Yeah, na. More we are
Yes.
Yes. So if I may just place this, lordships, this is a order of 22/9/2014.
Yes.
In person of the government letter dated number so and so dated 25/7/2013, whereby number of teaching and non-teaching staff have been created for Kamrup Rural District under the provisions of the Assam Venture Education Institution Provincial Life Services Act 2011 as amended, and under mentioned posts are hereby allotted to so and so school, which was recognized on 1/1/1993. So this provincialization is with effect from 1/1/2013. Now, in this school particularly, lordship will see the posts that have been provincialized and the candidates who have been provincialized against those posts. Lordship will see that even though the schedule says that there needs to be a music teacher, I'll take lordship to the schedule. No music teacher. So except for the music teacher, everything else, everyone got provincialized. Now will lordship kindly have this another document that ought to have been on record. But I'm sorry again, this. Now, this is an order of 6th June 2016, a very crucial document. This is the recommendations of the District Scrutiny Committee as envisaged in the 2011 Act. This is 6 June 2016, Provincialization of Services of Music Teachers. Sir, with reference to the subject cited above, I have the honor to state that a list of 204 numbers of music teachers is prepared after proper scrutiny. As per guideline mentioned in the government notification of the reference, it is clearly stated that these music teachers has been working as per appointment made by the respective school managing committee of venture education institutions before 1/1/2006 and recommended also by the district scrutiny committee concerned. These music teachers are now eligible for recommendation to get provincialization benefit. Further, on the list incorporating 10 numbers of working music teachers, those are qualified from Guwahati University as BU Music is also enclosed. These music teachers are also eligible as per the Act. Now, lordship may take it from me that the list is enclosed and our names feature in this 214 people who were finally recommended by the scrutiny committee to be provincialized. In all respect, if I may just point out, lordships, for your lordship's conviction, the first name, Daimala Basumatari, is the petitioner number 19. The number 1, Bankim Chandra Das, petitioner number 6. Then lordship will come to seriatim number 7, that is, he's the petitioner number 15 before your lordships. Then seriatim number 8 is the petitioner number 8 before your lordships. Seriatim number 11 is the petition number 26. 12 is petition number 17. Then if lordship will come to the next page, seriatim 15 is petition number 36. 16 is petition number 38. 17 is petition number 37. Then seriatim number 20 is the petition number 20 here. Then seriatim 23 is the petition number 4 here. Then on the next page, lordship, petition number seriatim 29 is the petition number 23 here. I can go on if lordship so wishes.
No, that's okay.
So therefore, lordships, after this, nothing remained to be done, except that 3 months from this date, the act came to be struck down. So therefore, today, lordships, and I will also point out, lordship, that the previous act had a deeming provision. So interpretation would fall that what would be the effect of the deeming provision in the act, which was there in the previous act. So having seen these bare facts, would lordship now come to the 2011 Act, which is at page,
Which was struck down.
which was struck down. We need to point out page
Alright,
49.
but Mr. Goswami, if you're relying on these documents, perhaps you will.
We have
bring
to,
it.
I'm sorry,
No, it's all right. It's all right. You can do it even now.
yes, I'm extremely sorry. Please come to page 49
Page 49.
of the writ petition. That's a 2011 Act.
Yes.
Assam Venture Education, lordship is at page 49.
Yes.
Kindly see the preamble, which may be important for the purposes of interpreting the act.
Yes.
And I'm not interpreting the act, the purpose. An act to provincialize the services of employees of venture educational institutions in the state of Assam and to restrict further establishment of educational institutions in the state. Now, please directly, Lordship, will come to the definitions clause. And I would like to draw your Lordship's attention to page 50, definition clause 2G and 2H. I'll just place it, Lordships. District Scrutiny Committee means the District Scrutiny Committee constituted under Section 10 for each district to recommend names of venture educational institutions which are considered eligible for provincialization of the services of the employees serving therein. So that 6/6/2016 order notification that I just handed over, Lordships, is a notification exercise of this powers. Section 10 is where the district committee is envisaged, and this is what the district committee is all about. Now, Lordship will see H. Employee means and includes all serving employees, both teaching and non-teaching, of venture education institutions who have been appointed by the concerned venture education institutions before the first day of January 2011 and whose services are being or would be provincialized under this act. Now, I will just pause here for a moment. There would definitely raise, a legitimate query would raise, what is the expression? Why are they using the expression are being or would be? Because these are two expressions that are being provincialized or would be provincial, and that answer we get it in the subsequent sections. That what is the feel of the legislature? Now will Lordship come to Section 3.
Yes.
Eligibility criteria for selection of educational institutions for provincialization of services of its employees. At page 51, the section is at page 52. May I just place it?
Yes, please.
Subject to the provisions of Article 30, that is the minority institutions of the Constitution of India, the following categories of venture education institutions shall be eligible for being considered for provincialization of the services of its employees. What are the conditions? The venture education institution which have been established. That's the first condition. And had obtained. Second condition. The required permission or recognition or affiliation or concurrence, as the case may be, from the respective competent authority or authorities before 1/1/2006. So there are two conditions here. It has been established and it has obtained the consent. Secondly, it has a minimum enrollment of 25 students. And third, in case of higher secondary or higher or degree, the concerned educator must have at least a consistent good academic performance, which would be at least 30%. Now, it is on instruction, I'm saying that we fulfill this eligibility criteria because in view of the 6/6/2016 order passed by the District Scrutiny Committee, which examined the records and thereafter recommend. Now, Lordship will come to.
Mr. Goswami, just pausing here for a moment.
Yes.
We have seen that this act makes way for provincialization service of the employees of the venture institute. But you just said it also provides for provincialization of the institution itself.
Yeah, because that is what
which is the provision which deals with it?
Yes.
2G and 3 speaks about provincialization of service of employees. Not
Please see P. P.
That is 2P.
2P. Venture high school means high school includes a high madrasa imparting education up to class 10 and established by people of the locality prior to 1/1/2006, which has received permission from the state government and recognition from the Board of Secondary Education Assam on or before 1/1/2006 and not provincialized under any act enacted by the state legislature so far.
That's correct, but that's not the answer.
No.
The question is different.
Yes. Section 3, eligibility criteria for selection of educational institutions for provincialization of its services and employees. So it is together.
Right. So this is very crucial.
Yes.
there should not be any.
Yes, because it
confusion.
says eligibility criteria for, first you have to select the education institution.
The employees of certain category of institutions, venture institutions, would be eligible for provincialization. This is
Not-
one thing to say.
Yes.
And it is another thing to say that this act provides for provincialization of service of employees as well as the institution. Because once the institution is provincialized, the consequences are very different.
Absolutely.
So I wanted to see if there any provision which all these provisions relate to provincialization of service of.
No,
employees.
lordships, please see
Yes.
3.1. Please see 3.1.
Yes, which you want to show? Section,
3.1.
section 3.1.
The venture education institutions which have been established and had obtained a required permission or recognition or affiliation or concurrence as the case may be from the respective competent authority or authorities before 1/1/2006. So they are talking about an institution. Now, with respect to the employees comes section 4. Who are the employees who will be in those institutions? Who are the employees who will have to be provincialized? Is section 4. Now, this is the most crucial section which has undergone amendments. Section 4.
Yes.
I will place special emphasis on this because this is the deeming clause. So we may have to section 4, employees to be government servants. The services of the employees of all eligible venture educational institutions under section 3. So, lordships, they are saying all eligible institutions under section 3 and who have already completed 10 years of service in such education institution without any break from the date of affiliation, recognition, concurrence, or permission, as the case may be, of the concerned institution as on date of coming of force of this act shall be deemed to have been provincialized, and they shall become employees of the state with the effect from that date. Now, please read this provision along with 2H, the expression R. Please come back to section 2H, where they have used the expression R.
Yes.
So that R connotes this.
Yes, this is in present perfect and
Yes.
past perfect.
And the next is 2. The services of all teaching and non-teaching employees who have not yet completed 10 years of continuous service without break in that venture educational institution under subsection 1 shall be provincialized.
Yes.
The services of all teaching and non-teaching employees who have not yet completed 10 years of continuous service without break in that venture education institution as under subsection 1 shall be provincialized with effect from the date on which they complete the required 10 years of service as stipulated under subsection 1. So this is where would be comes in under 2R. Now, Lordship will kindly see page 66. This section came to be amended. 4.1 came to be amended and it made it even more explicit. The legislature made it even more explicit.
Yes.
Page 66. In the Principal Act, section 4, for subsection 1, the following shall be substituted, namely, the services of employees of all eligible venture education institutions under subsection 3 shall be deemed to have been provincialized on the date of coming into force of this act, and they shall become employees of the state with effect from that date, provided such institution has completed at least 10 years of imparting education from the date of affiliation, recognition, concurrence, or permission, as the case may be, on the date of coming into force of this act. I may just pause and Lordship say in 2013, this section was further amended and this 10 years was replaced by 7 years, which is at page 76. The 2013 amendment is at page 76. If Lordship likes to have a look, Lordship can have a look at
Yes.
page 76.
76 is that notification.
Oh, I'm sorry. 2013, I think. Sorry, Lordship. This is at page 73. 73, section 2, amendment to section 4. In the Principal Act, in subsection 4, in subsection 1, for figure 10, wherever it occurs, the figure 7 shall be substituted. So finally, it became 7 years.
Yes.
So pausing here for a moment, Lordship, till now we'll see that the legislature was very clear in its mind that from the date of this act, because they were out for a purpose, that there was a lot of heartburn, people were on fixed salaries, venture or cap. So the preamble itself says, no more venture education institutions, but we are going to provincialize these. Now, having seen these sections, now the next section that Lordship I'd like to show is section 5 of that act.
Yes.
Section 5, terms and conditions of service. Subject to the provisions of this act and rules made thereunder, all rules, including service rules and rules of conduct and discipline, which are applicable to the state government servant of corresponding rank, shall be applicable to all employees of education institutions whose services have been or would be provincialized under the provisions of this act. So another indication of the legislature's mind. Then Lordship will come to section 6. It's very, very important. Management of education institutions from where service of employees are provincialized. With effect from the date of publication of a notification under subsection 4 of 10. That is the notification I pointed out, Lordships, with respect to the administration, management, and control of provincialized education institutions coming within the purview of this act shall vest in the state governments. Now, in our case, it's a very incongruous situation that my school is provincialized, but I still work there as a non-provincialized teacher, even though the schedule is there where a music teacher is also recognized. Now, Lordship will come to section 10.
So section 10, if it is to be viewed on the face of it, says all these institutions, the control and management will vest on the government.
Section 6.
Yes.
Yes.
That means whoever is connected with the institution comes within the control of the government. But is it a case that it creates an anomalous situation where although the institution is controlled by the government or is a government institution for all purposes, some employees are government employees while some employees are not? Was that the situation under the 11 Act because of section 6?
I don't know, but having spoken to my colleagues in the bar, there may be some cases of excess. Suppose the schedule says X school, there'll be 2 science teachers. But before provincialization, probably there were 3 people working. So 2 got provincialized, and the third one either continues as a non-provincialized teacher, or I really don't know. But there are issues there which other colleagues will argue. But
So those are the drop teachers, is it?
yes, but ours is not a drop teacher case also. Because there it says if there are more posts, then the seniority will come in, inter-se, and then though against the schedule.
No, that I have understood.
Ah.
The query was like, I'm just trying to understand because, so as I am concerned, this is the first time I'm getting exposure to this subject. So I need to understand some basic facts.
I share the same sentiment.
All I'm asking is, anybody can chip in with an answer. Under the 2011 Act, the scheme of the Act is such, it talks about vesting control of the institution, venture school, in the hands of the government. meaning thereby that the institution practically becomes a government institution. Then it talks about provincializing the service of certain teachers therein, meaning thereby that they will be treated as government employees. But in a government institution where there are government teachers, there are also private employees. Was that the situation?
The bar was given the earlier act, where we said that those who did not come under that provincialization thing would have no claim against the government at any point of time, and they would be left out. They no longer remain employees of
But
the
they
school or of us.
They did not continue in the school.
That is why there were several cases which came up, which say that we are allowed to attend the classes, we are allowed to do classes, but we are not being paid anything. They have no connection with the government, is what the provisions of the act was. That lordship would find at 5.
2011 Act.
Yes, 5.
Really, but looking at the constitutional scheme,
My lord.
my learned brother has shown that provision. It
Yes.
appears to be slightly bizarre that you are having a model where in a government institution, government
No,
teachers, and private teachers are.
No, we are not. We are not allowing them as private teachers. We were not allowing them as anything. They simply remained out of the scheme of
No, you
provincialization.
don't say you're not allowing. You
No.
said you will have no liability towards them.
It is because these institutions.
These are two very different things.
With these institutions, we had nothing to do. The government had very little to do with these institutions. They were private institutions which were not taking fees, where in sometimes they were having grant in aid and all those things. And when we found that no, these institutions need to survive, we took up
That is
some of
another
the.
matter. That you argue when the time
Well,
comes. But
so therefore,
for now, that aspect appears to be clear that the government has simply washed its hands off
those who could not
with
have been
respect to
provincial.
those who could not have been absorbed.
We
So-
washed our hands.
There is neither a beginning nor an end to this process. Suddenly, the government comes, takes over the institutions, some posts are taken over, and the rest they said that we don't know. You
One
do
of the-
whatever you feel like.
One of the very reasons why
question
the
is-
act was struck down.
Can the government act in this manner?
But this was one of the reasons why the act was struck down. This 2011, why it came down. And the other aspect was, while provincializing those teachers, we gave a total go by to NCT, to UGC, we listened to nothing, no qualifications were taken into record. People became teachers while being a matriculate. They became teachers of high schools. Those things were all taken into consideration by the Honorable Division Bench
We will see.
while striking it down.
We'll read that.
That judgment,
The
once we come
judgment
to
is
that.
part of the record.
Yes, we'll place it. We'll place it. Certainly we'll place it.
All right. Please proceed, Mr. Gupta.
Yes. Page 56 is section 10 of the District Scrutiny Committee. There shall be 10(1), there shall be one district scrutiny committee in each district separately for elementary, secondary, and for higher education to scrutinize service records and other related issues of the serving teachers and staff of venture education institutions pertaining to provincialization of the services. Now, 2 Lordship may skip, Lordship will come straight to 3. The district committee shall first scrutinize and prepare a list of all venture education institutions within the district which are eligible in terms of the provisions of this act, and shall thereafter proceed to scrutinize and verify the service records of all the serving employees who are eligible or would become eligible for being considered for provincialization of the services. 4, the district scrutiny committee shall forward the list of eligible teachers, school teachers, in accordance with the number of posts specified in the schedule appended to this act. This is important. Lordship will mark it. To the concerned director, who shall, after making such further inquiry as may be required, shall forward the same to the concerned department of the state government for consideration and for issuing notification in respect of the eligible institutions and employees eligible for getting their services provincialized. Now, the notification that I handed over Lordships sometime back, the 6/6/2016 notification is after this exercise was completed. Nothing remained to be done, basically, after this. Then Lordships will come to section 14, which of course is the These notifications have been used. Those section 14 is at page 58.
So is this not a notification of provincialization of service of your clients?
Which one?
This, 6th of June, 2006.
We say so. We say so. But the final order, they say there would have been a final order after this. We don't know what final order they're talking about. This is the order. But
But then
still,
why are you challenging the act?
yeah, but they are not
You
giving.
ask for amendments to implement this.
No, no.
order.
The question is, they are not being treated as that.
That's what we are saying.
Yes, Lordship, I get it. But they are,
Why are you,
I was,
why are you making your
I
task
put
so
the same
uphill?
question to him.
Huh?
He says, no, this 2000, now they show us the 2017 Act.
Oh, they can show you anything.
I was asking the same question to him, that we should have shot of mandamus on this, that implement this.
You should save the act and say that my right continues to be protected under the
The 2011 Act.
11 and the new act.
The new Act.
New act also does not take away your right.
No,
Where is the question of abridging your right?
2017 Act, there may be provisions that may come in the way. I'll point out. Therefore,
No. Does the 2017 act, it recognizes the provincialization of any of those employees under the previous act?
No.
that is the whole, they limit it to that 42,000 figure. So, we are not within this 42,000.
This is expression of the intent of the government.
I
This has to
bow
be-
down to your lordships.
this has
I
to
bow
be-
down. I bow down, but that 42,000 doesn't include this. So we say it should have.
Then your remedy would be something else. Why are you cutting that act which protects you? Are you not, I mean, Mr. Goswami, these are all evolving circumstances. Every minute is a learning experience.
Yes,
for all of
lordships.
us. Just thinking aloud, if you have this, and this is in consonance with section 6,
Section 4.
section 4
4.
and subsection 10, is it? Section 10 also.
Yes.
Section 10, subsection 4.
Yes.
This is an expression of the decision of the
This is
government.
the final expression.
You should ask for implementation of this rather than striking down of some act somewhere.
File and represent it.
We would then ask them that why how they can resile from this. Question we would like to ask Mr. Majumdar is under which principle of administrative law they can resile from this? That's the simple question. Answer to that, will write the judgment.
Therefore,
Why are you hearing this matter?
so therefore, we
Your
are saying
case-
that this has caused the vested, a vested right has been
Or
created.
by this, your client's service have been provincialized. Unless there is a provision in the subsequent act which abridges your right, it's only a question of implementation of this.
So if Lordship will see section 24, which is very carefully worded in the 2017 Act. They're very carefully worded that.
So is there any doubt on that front, whether the subsequent act takes away?
2017 Act, where they have, in section 24, they have specifically saved the provincialization of a certain number of teachers. And factually speaking, in those, these names are not.
Yeah, we can read down that provision then.
Yes, well, if Lordship said read down, there's nothing, then the whole problem is sorted out. If Lordship,
But you are not asking for amendments for implementation of this decision. What is the way forward for us?
no, we can always amend the prayer, Lordship.
No, that's okay.
I am so grateful.
Don't jump into,
Yes,
we are just, we are all thinking aloud to see which is the correct recourse.
yes.
But
And even
15
otherwise,
minutes, 20 minutes, whatever we have heard you. I don't know what my brother says.
even
I think your case is turned turtle. You are firing the salvo at the wrong target. That's what we feel. Subject to, of course, anything else you may have to say.
no,
You should ask for saving this rather than
so saving.
saving this.
Yes, sir,
You-
we want a direction that needs to
But
be.
where is the prayer?
Madam, problem তুমি অৰ্ডাৰতে গম পোৱা নাছিলা ন কোৱা কথাটো
Actually, Lordship, the problem was what this order was never known to us.
It's all right. Would you like to have a
Yes, certain,
rethink on
certain,
your
certain,
side?
certain. Let the others continue. We may, if let the other, because this
We'll
not.
keep it open for now.
Yes, sir, please keep it
Think
open.
about
Let the
it.
others continue and we may take the liberty of amending this prayer and seeking a mandamus for implementation. I'm so somebody else.
No, it's all right, it's all right. See, these are matters having very checkered history.
Yes.
Situations do develop.
Yes.
But the point is, we must try and do what is correct and which actually ends up delivering justice. Instead of going into
Certainly.
legalities here and there.
Certainly.
They will have to tell us how they can resign from this. And it has to be based on principles of administrative law. Is it not, Mr. Majumdar? We will go into the arguments of constitutionalism.
No, this is something which has come today. I'll have to go through this. This was not with the record.
So not there, I am.
Constitutionalism, rule of law, these are the things which will come into, and that will be purely in the
This-
facet of administrative law.
Section
You
24,
have
my lord.
expressed the intention of the government.
Section 24 of the new act, my lord, it withdraws and cancels all notifications made under the previous act. It withdraws this also.
No, but then how can you selectively save the provincial?
No, we have not provincial, the section 24, it allows for review of those cases also. Now, when we were only provincializing fresh under 2017 with the number of litigation coming in, that review is on hold. We have all the data with us, but we have not expressed a decision on that, or we have not taken it. Here, the fresh provincialization is under challenge.
You are
with the
reviewing,
number-
what is the criteria of review?
That
On what
aspect,
basis are you?
I have not called for the records of both.
Records are-
I'll bring it.
These matters
because-
can't go on like
Because
this.
when we provincialized under the earlier act, what I had just said, my lord, the educational qualifications or other aspects were not taken into consideration. Therefore, many persons who were not even eligible anywhere in the school are now serving as teachers. That has to be reviewed per the division bench judgment only.
If you say that you are doing a verification.
Not a
Verification
verification.
of the antecedents or whether they're having the qualification, that's one thing.
Mhm.
But if you're doing a review to see who should be kept and who should be left out.
No.
It will be hit by the principles of equality under Article 14 and 16. May have to,
May, my lord. That
may
is-
have to hold.
We,
And if that happens, then we have no option but to read down the provisions of those offending sections, at least insofar as this case is concerned. Because prima facie, subject to what you may say, our view, and I hope my brother also agrees to it, because this notification is preceded by an exercise under section 10(4).
Hmm.
Therefore, this complies with the statutory provisions and would be treated as expression of the government's intention to provincialize the service of the school teachers whose names are appended in the list.
my lord, the Punabati Brahmo judgment says that unless that order comes, no vested right, nothing is created in favor of any employee. There's a division bench judgment, which has been followed in about 10, 12 cases later on also by the division bench itself. In fact, in one of the cases, my lord, subsequently also there have been that judgment is an appeal. This is only the eligibility which has been brought on record. Whether a vested right has created or not, if lordship permits. The case is projected by the learned counsel for the appellant to the effect that the appellant was vested with rights under the Act of 2011 on the date when judgment was rendered in Chandan Kumar Neog Supra cannot be accepted. The very fact that the services of the petitioner had not been provincialized and therefore the writ petition was filed makes it clear that the case of the petitioner would not be covered within the four corners of the decision rendered on the review petition. That is how much of the entire judgment will, that will,
See, but.
therefore, that aspect
All right,
will have
all
to be.
Mr. Goswami, you want to continue? You can continue.
Just one thing, I won't continue. I heard it loud and clear from the bench. Just one thing.
No, we are not suggesting anything. We are just
No, no,
asking questions.
Just page 60 before I just conclude, because I just need to say that we are not excess also. Page 60 is the schedule. You see, these are all one teacher in each school. These practitioners,
Page 60.
page 60 is part of the schedule, and if your lordship will see high school, high madrasas, and if your lordship will see the post music teacher 1. And if you see that notification where that school has been provincialized, the music teacher has been opted out.
It was not there.
So we are within the cap.
Let them continue.
আমি একটু এডিশনাল এফিডেভিট দিবি আনি দিব পাৰিম কাৰণ কিন্তু তেওঁ কৈ দিলে ন যেতিয়ালৈ ঘটনা অরুণদায় ধরে দিছে বসছিল অরুণদায় ধরেছে বসছিল কিন্তু আপনি বুঝলেন কি এমএন করে করলে এমন যে করলে দিতে লাগে অর্ডার নহয় নিদিয়ে আমি এডিশনাল এফিডেভিট জানিলে কোর্টে উঠে দিয়ে দিব পারি সাইন জানি কি এডিশনাল এফিডেভিট করে আছে এই বস্তু যদি কিছু করে
Very
Mr. Goswami, please enlighten us on another aspect. We are looking at section 24 and the possible obstacle that can be created. Even if it can be held that no vested right was created, can this action of the government by issuing the 6th June notification and then resigning from it can be examined from the touchstone of Article 14 and discriminatory? So if that is another angle available, that judgment may not be of much significance. Absolutely. So if possible, show us 1 or 2 judgments, decided cases. We will have to do some work in. Mhm.
In fact, the immediate judgment is guilt, which is very clear on that you cannot. You have expressed it in a government order. So whatever you may say now,
And that police commissioner,
Gordon Das
Govardhan Das,
Gordon Das commissioner
Bombay Police Commissioner.
Bombay Police Commissioner,
1951
1951. Commissioner of Police.
AL 52.
Govardhan Das. Haji, Govardhan Das.
Govardhan Das Bhanji, yes. All right, so anybody else wants to argue in this group of 1 to 10 and 83?
come on
1 to 10. Are you also there in 1 to 10?
83 is mine. So Lordship, I may take liberty if necessary, I'll amend the prayer. Lordship.
Yes.
So grateful.
83 is mine. My lord, in 83,
Hmm.
these are around 50 venture college lecturers. They were appointed.
Just 1 second. You take down item 2. WPC number 8148 of 2018. Arguing counsel Manish Goswami. Petitioners are music teachers. By notification dated 6/6/2016. Director of Secondary Education, Assam, had forwarded a list of all music teachers, including the petitioners, numbering about 204, recommending their cases for provincialization of service. The learned council has prayed for liberty. Liberty and leave of this court to file additional affidavit bringing certain documents and record. Just put it at that. This is item number 2, WBC 8148 of 2018. Yes, yes, Mr.
And for them, basically, I endeavor to argue that after the repeal of the 2011 Act, pursuant to a division bench judgment, and in that case, my lord, the government made certain admission and concessions that yes, it was repugnant. Yes, it didn't provide for reservation and all. Then court granted 6 months time to legislate a new one. Now, my lord, I will be trying to convince your lordship that the 2017 Act as my lord enacted had certain gray areas. Even then, after setting aside of the declaring invalid, the 2011 Act, 2017 came. And I will submit that the 2017 new Act had some gray areas. And 2018 amendments incorporated certain provisions which makes it obnoxious, bizarre, and irrational on many a front. That will be my primary argument. And various sections, subsections, clauses are under challenge in a series of petitions, my lord, here. Challenged by, my lord, various levels of teachers and employees of education institutions. They are also employees. Junior college, primary college, high school, higher secondary. Here in my case, my lord, there are about 50 venture college teachers, lecturers, all of whom were appointed, my lord, between 1999 to 2010. And there is a chart, my lord, I have given, Annexer B at page 200. And all of them are either PhD or net slate pass. All of them. I have stated that, my lord. And my lord, 2200, page 200 is the chart. Lordship will find who joined when. For easy reference to, for your lordship, my lord, the chart has been prepared based on their appointment letters, my lord. Lordship will see there are different colleges, they are working, imparting education, taking classes in different subjects in different venture colleges all over the Assam, all of Assam. And these colleges are under, my lord, Guwahati University, vis-a-vis the Dibrugarh University and other existing universities, which are running under a state act. My lord, lordship, kindly see, subjects are different, economics, some are teaching physics, Assamese, political science, sociology, education, Arabic. And my lord, the date of appointments are like this: 2007, 99, 99, 2001, 1, 2002, 3, 3, 3, 4. Next page. Again, different subjects, my lord: history, botany, physics. And date of appointments are, my lord, 2005, 6, 2006, 7, 7, 2008. Lot of them are in 2008. Then 2009. Political science, philosophy. So 2009, many of them were appointed. And the last few of them are appointed in 2010. So all, my lord, by 2000. And all of them, I have stated categorically, have obtained their PhD or net or slate. I have not annexed all those certificates. If called upon, I also keep question. My lord, they haven't been provincialized as lecturers or teachers in their respective subjects, either under the since repealed 2011 Act during its existence, or the earlier Act of 2005, Provincialization of Employees, College Employees Act, although many similarly circumstanced teachers were provincialized either as lecturers or some of them as tutors from time to time, even pursuant to High Court's direction also, some of them. And even there are persons who joined later on than me. Now the impugned provisions of 2017 as amended by 2018 Amendment Act have become absolute stumbling block for our any prospect for provinciality. Therefore, I am challenging these provisions. Now, lordship may kindly, before I go to various provision subsections, let me show your lordships, show to your lordship which are the provisions specifically under challenge in my petition. For that, lordship may kindly go to page 2 of the cost title.
Yes.
Second cost title, constitutional, page 2.
Yes.
Constitutional validity and virus of section 2JT and definitional clause. There are certain self-contradictions in these definitions themselves. Section 4.2, Roman 3, and section 8.6 of the Assam Education Provincialization Service and Teachers Reorganization Act 2017 as amended. I will, my lord, refer and read all these provisions, not from the compilation book, but from the Assam Gazette notifications, which I have annexed in my petition. I will not refer to my friend Sutia's compilation. I have annexed the Gazette, not now. When I refer, I will refer to the Gazette notification. So it is absolutely error-free. Now come to the next step of clause.
It appears to be a very loaded suggestion.
Lordship,
It appears to be a very loaded suggestion. Absolutely.
that book is very handy, I must say. The binding is bad. Binding is bad, very bad.
Okay, problem is with the binding.
Problem is with the binding. Page 2, I am still reading. Topmost clause. Lordship will see, here I have challenged the constitutional validity of the entire act. Education Provincialization of Service and Teachers and Reorganization Act of 2017 as amended in 2018. Why I have challenged the act? Because ultimately my last limb of argument would be doctrine of severability, corollary to which is doctrine of inseverability. When so many sections, if ultimately 1, 2, 3, 4, 5 sections or vital sections and subsections or clauses, if at all, ultimately held to be bad by your lordships, then the remaining provisions cannot constitute a valid act to carry forward the object of the act itself. Therefore, doctrine of inseverability will come, and right from 1957, there are decisions which will be my last decisions that I will be citing before lordship after the others necessary decision. Am I clear?
Absolutely. But one question here. This is an act by the state assembly, correct? It is not only customary, but also requirement of law to issue notice to the AG. And the Advocate General normally is.
Yes,
heard in this matter.
he would be appearing. Madam. Yes, he'd be appearing.
He will be replying.
He'll be replying, madam. Once the arguments come over, AG will be here.
Now, my lord, these teachers, in my petition, have been serving these teachers have been serving for long years, as I have shown right from their date of joining, from 1909, 2000, 24 years. Some of them 22 years. Three things are clear. All of them have the requisite educational qualification, even otherwise to be provincialized as teacher or lecturers in respective subjects. You require master degree? I have. You require NET or SLET pass? In lieu of PhD? I have. And I have PhD. All. Number two, their colleges are affiliated either by the Dibrugarh University, Guwahati University, or any other existing university within the territorial jurisdiction of some, and the territorial jurisdiction of respective universities. Western Assam colleges, territorial jurisdiction is Guwahati University. Dhemaji, Lakhimpur, Dibrugarh, Tinsukia, the territorial jurisdiction of Dibrugarh University. I will refer to the acts of both the universities and their statutes and ordinances. Then thirdly, these colleges that they are serving had got concurrence from the competent state authority to run classes from first year higher secondary to final year graduation in various subjects. They had the concurrence and they definitely had the affiliation of the university, and therefore for last so many years, batches after batches students are passing through. Good or poor results differently, including major subjects. Now, my lord, the grounds of challenge, I have, my lord, stated this, what I have said, these three things, paragraph 17, paragraph 3, I will not disturb your lordship, I have averred it. If it is found and demonstrated clearly that the impugned provisions, even one or two of them are contrary or overlapping with any central act, or for that matter, any state act on the subject matter of education, which is there as entry 66 in the concurrent list, then, my lord, the impugned act will attract matter repugnancy under Article 254, 2 and 3, 1 and 2 of the Constitution for going against or being contrary to any provision of the Central Act or for that matter state act. Talking about Guwahati University exists under the Guwahati University Act, which still exists, and that too is a state act. Similarly, Dibrugarh University. This act has, second thing will be, if it is overlapping, this act has only gubernatorial assent and not presidential assent, which ultimately your lordship may find that in such a situation, it must have, you ought to have had presidential assent. Kindly turn to page 204 of the Gazette. 204. This is Assam Gazette notifying the 2017 Act. Following Act of the Assembly received the assent of the Governor.
Yes.
So this Act doesn't have presidential assent. Also, my lord, the Impugn Act doesn't have any express provision in it saying that notwithstanding anything contained in the Dibrugarh University or Guwahati University, this 2017 Act will override and prevail. Applicability over the other University Act. Like before the repeal and saving clause, in state acts, my lord, normally there are many state acts. There is a provision which says, notwithstanding anything provided in any other state act, the provisions of this act will prevail. No such, my lord, expression in this act. Lordship may go to,
There is no non-absent clause.
yes, yes, right. Lordship 226. 226, section 20. It is the power of interpretation and removal of difficulties. If any difficulty arises in interpretation of the provisions, interpretation of the state government shall be final. If any difficulty arises in giving effect to the provisions of this act, the state government may by order do anything not inconsistent with the provisions of this act and the rules framed thereunder which appear to be necessary or expedient for. It doesn't say that come what may, in any other act, any provisions will be overridden by this. So no express provision, my lord, expressing that this act will override any other state act's provision. Am I clear, my lord?
Yes.
Lordship may see what are the acts I have stated, page 24 of my petition.
Yes.
Ground up challenge, capital letter B. The impugned state act hasn't received the assent of the President of India. Therefore, the very enactment is violative of Article 254, 1 and 2 of the Constitution of India, in as much as the impugned State Act 2017 as amended contains provisions which are contrary to the scheme and postulations of National Council for Teachers Education Act, University Grants Commission Act, and regulations guidelines framed thereunder, and therefore is liable to be declared void. I believe in many other cases, my lord, this ground is being cited. I will come.
So it is, because it is concurrently subject, so presidential assent is required.
Yes, yes. And D, my lord. D, I have stated to page 25, capital letter D, ground number D. Impugned Act 2017, which its infringing provision challenged in the writ petition are squarely opposed to the provisions of the Guwahati University Act as well as the Dibrugarh University Act, and the Impugned Act is therefore ultra vires in absence of its overriding effect applicability over the provisions of the University Acts. Those are stated. Then next paragraph 10. Oh no, I stop here for the time being. So I will, my lord, refer to the Guwahati University Act and the Dibrugarh University Act and the relevant statutes framed thereunder. At the time when I will be drawing your attention to two of the clauses which fixes minimum number of students to be enrolled and minimum number of students to have passed the last final examinations, which obstructs us. There I will show that, my lord. This is just to keep it in, my lord, kindly keep it in mind. Now, my lord, my next ground will be this act as amended by 2018 Act nowhere defines what is additional post for a subject. Definitional clause from A to Z. The additional post is never defined. Which posts are called additional? Which post you government want to call additional? Posts are posts. Under the University Act and the other central acts, UGC Act, the various guidelines, the University Statute for affiliation, posts are treated as posts. Every subject is equal and equally important. Not that only physics and mathematics are important, history is not important, education or geography is not important. Every subject is equal. Then why some posts are posts simply citer and why some posts of teachers are additional posts? Posts are posts. Duties and functions are same. Impart task. What makes the post in a particular subject as first post, second post, third post, and then additional post? The government will, your lordship will have to put a queries to the government on this. The act doesn't specify. I'll refer to the Gazette Notified Act, my lord, again. The word additional post is suddenly brought in clause Roman 9 of section 3, subsection 1 at page 232. Page 232. This is the 2018 amendment. This
Yes.
clause, first I'll read the Roman 9 clause, my lord. Roman 9 clause. For provincialization of services of additional teacher. This is the first time that the twin words additional teacher has been inserted in this act. In the definitional clause, section 2, A, B, C, D, Z, no definition of additional teacher. Teacher is defined. Lecturer is defined. I'm taking your lordship to clause 2 at page 220, section 2, the definitional section, page 205. Just have a bird's eye view.
Yes.
A, B, C, D, page 205, definitions. These are, my lord, words and definitions brought in by various erstwhile acts, right from Assam Act 1961, 1984, so forth. Deputy Director School. Then Z 206, employee is defined. 206, J, employee means include all serving teachers and tutors as the case may be of venture educational institutions appointed joint in the concerned venture educational institution before first day of January 2011 and whose services are being or would be provincialized under this act. 8, my lord, postulates, this is the postulation of venture teachers, all come within the definition of employee, that your service will be would be provincialized or are being provincialized. If at all this is to be done, this is this 2017 act under which this is to be done. Then all other things, governing body is mentioned. Because they've visualized that there are venture colleges which are managed by the governing body. Provincialized school, provincialized college. Then next, teacher, T, page 208. Teacher means teachers, assistant teachers, classical teachers, also includes lecturers like us. Assistant professors, associate professor, professor, principal, vice principal, demonstrator, headmaster, assistant headmaster, and any person of the teaching faculty working in venture educational institution, having required educational and professional qualification as per norms, standards fixed by the right to children, my lord, that is for the primary level, not for the graduation level. These other two acts will come. National Council of Teachers 93, University Grants Commission Act 56, and the relevant rules, regulations framed thereunder, and any other act as the case may be, like Guwahati University Act, as applicable on the day of provincialization and whose services are provincialized on the post of teacher or any other post. Then tutor is also defined. I will later come to the distinction between teacher and tutor. Then university is defined. Venture degree college, W. So nowhere, here teacher is defined. Nowhere it talks about additional teacher. No definition. Suddenly, it is skyfallen in clause Roman 9. That he is a teacher, he is teaching geography, you are teaching this subject, he is teaching this, these two are first and second, you are additions. Absolutely, my lord, irrational. I'll come to that. And my lord, it is Vijay. This is absolutely irrational. Even in, I can say, my lord, clause 9, clause Roman 9, again, my lord, 233. Let me read it. Roman 9. I was halfway through, I was reading it.
Yes.
For provincialization of page 232, Roman 9. For provincialization of services of additional teacher or tutor, as the case may be, for a particular subject, including the core subjects. Here again, my lord, what is core subject? The act doesn't specify. What do you mean by core subject? Is it history or geography or education or physics? Yes, you talk about major and past core subjects. Earlier it was honors. This is the word here. For a particular subject, including core subjects, in addition to the post mentioned in section 3.1, Roman 4, I'll come, my lord. In any venture high school, so and so, venture higher secondary, venture senior secondary, skip this space, then 233, in addition to the post mentioned, then in a venture degree college. Yeah, 233, in addition to the post mentioned in section 3.1, Roman 7, this is oblique. This is, here is the disjunctive portion. In a venture college, the minimum students appearing in the last final examination of the highest class for that particular subject must be more than 150 for one additional. The word additional is repeated. It is absolutely absurd, irrational, arbitrary, and unrealistic. Expecting 150 students to appear in the subject of education or history in the final year of graduation. And nowhere it is provided. It is contrary to other legislations. This provision appearing, and it is now I will take your lordship how this provision is also contrary to other provisions of this very act. Contradictory, both ultra-virus and intra-virus, both. Forget about Article 14 unconstitutional. Come to Roman 4, Roman 7, previous page. For provincialization of services of one teacher or tutor, as the case may be, in each subject, including the core subject, core. It doesn't say what is core. In case of so-and-so, 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 come below. Last three sentence. In case of venture degree college, at least 15 students in that particular subject must have appeared in the last final examination from that college. There you said 150. Here you are saying 50. I go by which? Senior secondary classes are also there in the venture colleges, my lord. So it is not, it is therefore, my lord, what ultra-virus or ultra-virus. And to expect 150 students, I'll show the prospectus of premier colleges like Bibora College, Pandu College, Ajjo Vidyapith College. See the total number of seats there. They talk about 150. In college like Bibora, Pragjyotispur, last final examination, 35 appeared.
Hello. দুটা সেট আর একটা লক এটা এখন আছে তিনজন
Let us have a look at these prospectus. See the, my lord, Pandu College first. Come to the second page. Number of seats available in various disciplines. Science major. Science stream is 265. Total number of seats allotted for the science stream, meaning thereby it includes total physics plus chemistry plus mathematics plus botany plus zoology. Lordship has seen the numbers
Yes, yes.
for 35, 40, 35. Then come to arts, Assamese. One thing, English, my lord, is a compulsory subject and MIL. Definitely, everybody has to have English. Therefore, definitely, my lord, number of students will be more in English department in any damn college. Then commerce, 35. Then come to the next prospectus. It is of my lord, Pragjyotis College. Here, my lord, this college has, my lord, total 300 seats in the Bachelor of Arts, all subjects. There are about, my lord, 10 to 12 subjects in the arts stream. Total number is 300. Next page. Kindly have a look. BA Honors, number of seats. Anthropology 10, Assamese 10, Bengali 10. Bodo, naturally, my lord, regional will be lower. Economics 23. Then education 30, English 30, geography 25, Hindi 18, history 25, mathematics 2, BA honors, philosophy 25. None has got, my lord. So this, my lord, is also against the 1:30 ratio, which I'll show. Supreme Court said, UGC said, the teacher students ratio in a classroom will have to be 1:30. How can there be? And all teachers in Pragjyotis, Bibura are provincialized irrespective of number of children. You cannot apply an act discriminately. Then, my lord, Ajjo Vidyapith, have a look. Last one.
So you are relying on these documents to show the manner in which the act is being applied. There is no consistency. It doesn't follow any beaten track. That's what you are saying.
These are the premier colleges. Bibura, Pragjyotis, Pandu, premier colleges. We are from Dhemaji, working since 2001, 23 years in events and solutions. PhD, I am that time a doctorate. It is not number one, it is doctorate. So therefore, expecting, my lord, the compulsory subjects like English and Assamese alternative, far less number of students appear in final examination. In all other subjects, even majors. So therefore, this provision is bizarre, irrational, absurd, unrealistic, and therefore it violates the fundamental rights under Article 14 and 16. This pave way for inequalities. You are expecting 150 students to attend the last final examination in the subject history from Dhemaji College. Then only you provincialize. Even though I possess all the qualifications, like a Pandu College lecturer, I have 52.5% in master degree plus a PhD from Guwahati University. Because of the employment market, I am serving there in Dhemaji or Sinapotha College. Now, my lord, I will be referring to the statutes on affiliation of old and new colleges. And these statutes, ordinance, orders, bylaws, etc., under the parent state university acts are also law. Before I refer to what is called Dibrugarh University Statute on Affiliation of Guwahati University Ordinance on Permission and Affiliation of Degree Colleges, why I am not referring to the parent act, Guwahati University or Dibrugarh Act? Because of, my lord, necessary constitution there. Lordship may have a look at article, my lord, 13(3)(a) of the Constitution. This may not be act. This may be, my lord,
Yes.
it is also in the context of, my lord, derogation of the fundamental rights. Laws inconsistent with or in derogation of the fundamental rights. All laws in force in the territory of India immediately before the commencement of the Constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. Number 2, this is important. The state shall not make any law which takes away, abrogates the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of contravention, be void. 3. In this article, unless the context otherwise requires, law includes any ordinance, order, and even bylaw, rule, regulation, notification, custom, usage having territory of India. Therefore, it may not find place in the parent act of Guwahati University. The student ratio or the enrollment ratio, if it is specified by Dibrugarh University Statute of Affiliation, this by itself is a law. Am I clear to you also? Laws in force includes laws passed or made by legislature or other competent authority in territory before commencement of India and not previously. This is not necessary in particular. 3A is important. Now, Dibrugarh University's statute. What will be? Okay. Photocopy. Yeah.
Mr. Barbara, we'll request your junior to give us a very short note on all your arguments.
My lord,
Just broad points.
I'll give a written argument, my lord. And why it will be, if I am asked to give that, after the government gives I will have the right of last reply after that. Now it will be halfway through this note. Have a look at the Dibrugarh University. It is called Statute on Affiliation of Old and New Colleges. It's very difficult to obtain these, my lord. Lordship, F. Colleges with complete pass course and first and second year honors classes. As in D, I don't have that page. Here, next, in subjects with honors, as follows: arts, commerce. In each subject, 3 lecturers, except in English and any other elective subject in which there shall be at least 4 lecturers. In English, there shall be 5 lecturers in colleges providing instruction. Then G. Colleges with pass course plus first, second, and third year honors class. Arts and commerce, 4 lecturers in each subject. Why then? first, second, third, fourth one becomes additional. How can you make it additional? Fourth post. First question first. How can you make it? University says four posts. Posts are equal. Posts are post simple cycle. What do you mean by additional post? Then, my lord, 27, there is a clause, my lord, paragraph 18. Irrespective of other requirements, the total staff-student ratio in a college should not be less than 1:30. Now, I have shown Viburu and Pandu. Lord Simay asked them whether the anthropology lecturer in Pandu College is a provincialized teacher or not. Teaching 10 students, last exam, final, appearing. It cannot be more than the seats.
Mr. Majumdar, you are making a note of all these submissions. You have to, will expect a reply.
Then, my lord, Guwahati University also, teacher students ratio minimum 1:3, 1:30. Now, my lord, one more. Let me do it. Now, my lord, before having a look at this, my lord, let us visualize one situation. Teacher-student ratio in a situation, in a given year, say the number of enrollment and number of students appearing in the last final examinations are as mandated by this improved provision. You provincialize the subject-wise teachers. Next year it falls. Are you going to deprovincialize them? Are you going to deprovincialize them next year? 150 is far enough. 40 teachers. You provincialize. You have been doing it. Next year it comes down to 25. You deprovincialize that post. When you enact an act, it must give all the guidelines and guiding principles should be evident from the context sections of the act, which are not here. They are simply mandate things. They don't give any guidelines. No guiding principles in the improved clauses, one after another. Now, have a look at the Guwahati University. I have shown Dibrugarh University. Second page, there is a chart given. BA, minimum requirements of teaching staff for 3-year degree course. BA general plus major. Up to first year 2, up to second year 2, up to third year 4. So you provide it. This so-called second post occupier then again general plus major up to first year 2, up to second year 2, up to third year 4. Same college. Subject wise. This is subject wise. Now I will imagine from 10:30 to 45 minutes class, the second post occupier takes the class. At 12 o'clock class, I also take their class, the second class. So, is it a reasonable classification? Would you
No,
object?
that's all right. Mr. Barbara, just wanted to ask you one thing. You are challenging the provisions of the statute. What are the grounds?
These are the grounds. I am already on my third ground.
No, if your ground is that the act is not being applied rationally, that cannot be a ground to strike
No.
down.
Basically, the other state statutes
Hmm.
on this subject matter of college teachers speak something, your act contradicts it, And you don't get even the presidential assent for that.
Presidential assent, that is a technical point.
The-
If the act goes on that, it goes on that.
Then number two,
Do you have any authority on that point?
I-
You have,
Certainly.
so you can, please, if you have one authority, please give it to us.
On
Because
repugnancy,
if the enactment on a concurrent subject requires presidential assent, then unless the assent is obtained, this is not an act.
if your lordship finds that, yes, it contradicts certain things, certain clauses or sections in the Guwahati University Act or statute, Dibrugad University Act, State Act. It contravenes certain provisions of the University Grant Commission Act or the various ordinances and guidelines framed thereunder, which too are law, within the meaning of Article 13(2). Then, but repugnancy clause will,
Repugnancy is not a ground to strike down a statute.
repugnancy will come then. 254(2) will come.
Hmm.
2 will come. But suppose if it is not repugnant to the central act, it is repugnant, it is contrary to some state acts, even then you have to take.
Just
Because
1 minute. Just
in absence of an overriding provision,
168.
express. So, 254. Here, my lord, 254, I am reading. If any provision of a law made by the legislature of a state is repugnant to any provision of a law made by parliament, which parliament is competent to enact, or to any provision of an existing law, here I fall. I have shown the statute of affiliation, with respect to one of the matters enumerated in the then subject of provisions of law made by the parliament, whether passed before or after the law made by the legislature of state, as the case may be, the existing law shall prevail, and law made by legislature of state to the extent of repugnancy be void. Where a law made by the legislature, second, where a law made by the legislature of a state with respect to one of the matters enumerated in concurrent list contains any provision repugnant to the provisions of an earlier law made by parliament, or this, I emphasis on this word, or
Yes.
an existing law with respect to that matter, then law so made by the legislature of such state shall, if it has been reserved for consideration of the president and has received the assent, prevail. Otherwise not. Otherwise not. I have shown, Repugnant University says something, Guwahati University says something. In this impugned Act 2017 as amended, you don't have an overriding provision, express overriding provision. And your act contradicts Guwahati University and Repugnant University postulations. In that case, when there are contradictions between two state acts, you must obtain presidential assent. I'll try to develop that.
All right.
And then, my lord, one document, 234, there was a staff pattern. Government gave a staff pattern. Kindly have a look at page 234, Annexure D.
So you would like to continue?
No, just this document, with this document, I conclude for the day, my lord. Page 234. My lord, 2011 Act provincialization was set aside. Earlier Act was 2005 Act, my lord, provincialized. This is a circulation, my lord, circular given on December 2008. Have a look kindly. This is by Director of Higher Education.
Where is it?
Page, my lord, 234. Staff pattern. Subject staff pattern of the degree college. With reference to subject cited above, I have the honor to furnish the staff pattern of degree college as below. Lecturer, 3 pass course plus 1 for major course. So this is your existing staff pattern. This is your existing staff pattern by the head of the my lord. higher education. So how can you now say that he is an additional teacher? You can at the most be an additional teacher or be a tutor. So, suppose my lord, the threshold, if I am not available here, lordship may take in between, my lord, I'll definitely be
All
here.
right, all right. So
There are so many.
anybody in 1 to 10, anybody else minus
My
item 2? anybody?
friends are, so many friends of
Yes,
mine
yes,
are also.
everybody will just get a feel of these matters.
Lordship,
So between
lordship.
1 to 10, which is your case, Mr.? Your item number?
My lord, my item number is item 3, 5, 7, 8, 9, and 10, my lord.
Mr. Air.
My lord.
Item 3, 5,
3, 5, 7, 8, 9, and 10 all relates to music teachers, my lord. My lord, what my respected senior friends, my lord, has already argued. My lord, I am endorsing the same argument. One thing, my lord, I would like to draw my lordship's precise attention, my lord, that regarding that, my lord, deeming provincialization, my lord, prospect, which is my learned senior friend, Mr. Goswami, has already brought into my lordship's notice, my lord.
yes, yes.
And in that respect, my lord, already there are several judgments. Already there are several judgments have been passed, my lord, by the learned single judge, my lord, that there is a mandamus has also been issued.
Hmm.
That those persons, my lord, whose name has already been recommended and they deemed to be provincialized, and the order of provincialization is just held to be a formality. So therefore, my lord, a mandamus had been issued directing the authorities, my lord, to provincialization of their services and, my lord, to extend the benefit, my lord. That is one aspect of the matter I am adding.
There are already decisions. in that.
Already decision of the learned single judge, my lord, and 2-3 decisions are there, my lord. And wherein, my lord, I was also a party, my lord. In that case, although the mandamus has been issued, but till date, my lord, the state has not complied with the same. And some contempt petitions are also pending. And secondly, my lord, in advancing to that aspect of the matter, my lord, in my petitions, my lord, we have basically challenged the provision of section 424, my lord. 424, my lord, which I would like to, I have already made a part of the record of the same, my lord, page 140 of, my lord, item number 3, my lord, may kindly have a look, my lord.
140.
140 of item number 3, WPC 3110 of 2019, my lord. This is the clause, my lord, which is now creating the all hurdle for us, my lord, that why we cannot be provincialized, my lord.
Yes.
Lord, it says that in case of teachers and of the tutors of the school for the special subjects like Sanskrit, Arabic, Hindi, craft teacher and music teacher, my lord, we are music teachers, my lord, and other classical teacher, the number of students appeared in the concerned final examinations like SSLC and higher secondary 10+2 conducted by the SEBA or the Assam Higher Secondary Education Council as the case may be, shall not be less than 10 students in each class per year during last 3 years. This is the hurdle, my lord. They have created a class. My lord, what I respectfully beg to submit, my lord, that under the 2011 Act, there was no any such provision was there. And my lord, such music teachers has already been provincialized. Now by of 2017 Act, my lord, this classification they have brought in, and thereby, my lord, from the same set of people, they have tried to, my lord, classify the two distinct sets, my lord. And this is in violation of Article 14, as well as we have been deprived from equal opportunity in the public employment, which has also infringes, my lord, Article 16 of the Constitution of India, my lord. So these are the issues, my lord, which I have raised in my petitions, my lord. Adding other grounds are also there. But as my respected senior friend has paused his submission, my lord, regarding that deeming provincialization, my lord, and I am also pausing the same at this moment, my lord. If required, my lord, we will advance the other part,
Okay.
my lord.
So you please give a short
My lord.
synopsis of your
Yes,
argument.
yes, my lord. My grounds and arguments I will provide in item number 3.
Mr. A.R. Bhuya, items you have written, rest I'll tell you what. to
My
write.
lord. My lord.
So we have finished 1, 2, 3, 5, 6, 7, 8, 9, 10, and 80.
9, 10, and 80, my lord.
Who is in item number 4?
My lord, my friend is there. My lord, in my petition, my lord, I have prayed for a mandamus. In this petition, that basing on my earlier recommendations, our services should be provincialized, my lord. That prayer is here, my lord. Obliged, my lord.
In item 4, you have Mr. G.
Yes, my lord. I am adapting, my lord, the summation of Mr. Goswami also and my current friend here, my lord. Well, similar, and the pleadings are also similar, my lord.
You are also music teacher,
Yes, my music teacher.
all music teacher.
Yes, ma'am. And my lord, regarding this
You are
prayer
music
also,
teacher.
already in my lord, writ petition for Damas in this regard, my lord. Because this petitioner also in the list, man.
Correct. Anybody else in this group? You are in item? Item 6, MP Sharma, right, music teacher. Same argument? Correct.
Item one, Suki Chaudhary was.
Item 1,
No, that teacher, same argument, but Ken Chaudhary will argue in this case, Mandal. I have engaged Ken Chaudhary. He left once.
but he is not visible. All right, so,
I'll also submit
one,
some
Ken Chaudhary.
arguments or some.
we put it like this, the thing will be group A. Item 1, then item 8,
No, if individual represents.
then item 2,
That will be.
then serially rest of this, 1 to 10 and 80, this will be group A.
You pay.
When you type out the order, put it in this order. Item 1 and item 80, and top, then item 2, and then rest of the items.
Just one point out, also, we actually, I'm sorry, Ashita, we have already prayed for mandamus in our petition. With respect to that recommendation, that mandamus is already there, sought for. mandamus.
What we will suggest is, please have a short note on,
Yes, and I have to also give your lordships our interpretation on deeming clause, because that would play a very important.
this is a new point, Mr. Barbara has argued that if the act required assent. of the-
Essential asset.
Is it correct? Is that the obvious?
I'll have to examine, but if it's in a concurrent list, then perhaps that may not be so strict. But I'm giving benefit to
He
that.
argued, but he was not very forceful about it.
Yes.
But if that is a real issue, then it's going to be a very critical issue.
Yes.
That will render the act null and void without the presidential assent. If it is mandatory.
A concurrent list, maybe the governor can also be.
What is your
The first time we will answer together.
first time? Just examine it.
But our opinion as of now, we are discussing, it is not required. It would not require the presidential election.
Most likely.
Because the
The central act, if it's in this.
central
one,
act, what it
may be
deals
different.
with and what we have dealt with in this
There are
sector.
some category of state acts. which
That would
requires-
require.
What is that? Which is that category? Some acts enacted by the state legislature requires presidential assent. Find out.
Huh?
There are some. This may not be in that category, but there are some. This will be of some use to you later on. All right, so this group A is over. Group A 11 cases is over. Let us now move on to the next group. Which is to the next group. Starting from 11 to 20.
My lord, I believe these matters are being taken on day-to-day basis. These matters.
No, we will have it again posted and then we'll do it day-to-day basis because tomorrow it will not be possible. After that, Friday also there is some assignment. Next week,
No, it's always
Which
for
is
you, my lord. I am knowing my
what we are suggesting is, can we? I will have to make a request to the Honorable Chief Justice. So that we can continue. Otherwise, this half-day business is not very convenient.
After all, it is written
Matter
as a
like
special bench to take up this matter.
Correct.
That's
So
for your
Why
lordship.
don't we? From 18th June, 18th, 19th and 20th, 3 days we will keep and finish it off.
Gap should not be more, gap should not be more, my lord. That's
No, no,
what.
18, 19, 20, day-to-day basis.
Lordship, I like to again refresh your lordship.
No,
then.
it's just 2
This
weeks.
is my only case. Your lordship deal with hundreds of cases. daily.
Otherwise, Lordship, in item 83, Lordship, last week notice was issued, we have a search case, we have to file reply also, Lordship. In 83, Lordship.
I find reply, but these
83
are all
Lordship.
law.
Actually,
Lordship.
actually, I am arguing on absolutely on law matter. So in those prospectus, he can give that.
if your lordship is fixing 18, 19, 20, for 3 days, I think is fine. 3 days at a stretch, your lordship can
Yes.
hear it.
Otherwise, it is
Good.
not convenient for us.
No,
also.
this way, my lord, I remember very well, arguing before a division bench, it was heard. Like one of the lawyer was asked, given some time to argue and place it before this court. No, because when our turn comes, then will be different than what Mr. Goswami 1 to 10 has argued. Because we are basically under section 3. That's, I don't know about others, 3.
So
It's
just,
very
just
important.
1 minute. Group B will be item 11 to 11 to 21. And then group C, 22 is single. All right. 23 to 24 will be group C. We have to name group A, B, C, D like this.
It
for
will be
easy
better.
identification.
Lordship, I am indicating one thing. Lordship, 18, 19, 20, Lordship, learned as you will be not available in Assam, Lordship. He will be, Lordship, 18, 19, 20.
And when?
Then,
Then it will be difficult. You have to make alternative arrangement.
induction.
Their turn will come later, my lord. There are
Then no issue,
lawyers,
then no issue.
lot of lawyers.
Then no issue.
Petitioner side will take time. Only petitioner, not only me. There
We
are
have all
others.
the petitioners. What I will request is, if all the petitioners, councils could give a very short note of your submissions. We will start preparing the judgment. And so that we don't miss out on any point. We just prepare the judgment.
We hand it over today itself.
No. You can do it either on the next date when you make your argument or any day prior to that also, it's fine. 18, 19, 20. You write like this, then as senior counsels, Mr. B.C. Das, Mr. A.C. Borpura, Mr. D. Das, Mr. K. Chaudhary, have, along with Mr. M. Goswami, Mr. A.R. Bhuya, and Mr. G. Uddin, Mr. M. P. Sharma, and then counsel appearing for the respective petitioners have addressed arguments today, but the hearing remains inconclusive. In view of the above, let these matters be listed again on 18th of June 2024 as fixed items. An attempt considering the nature of issues involved and the number of councils connected with these matters. Registry may explore posting these matters for hearing on day-to-day basis. Other side, we give Mr. R. Majumdar, Mr. K. Gogoi, and Mr. Andre Katonia, along with Mr. D. Nath Leonard, Additional Senior Government Advocate Assam, are present on behalf of the respondents. All right.
Yes.
So we'll have it on day-to-day basis because the Honorable Chief Justice has constituted a bench
No,
with
Lordship,
myself and fix some matters which will,
Bench will be from 10:30.
sorry,
Bench will be from 10:30.
10:15.
From morning, the whole day.
you want it from 10:30? Mr. Goswami, you are not in Delhi.
I'm very much from here. Lordship, just give me a liberty to
Guwahati has its own rules.
Sun rises earlier.
Lordship seeking a liberty to file an additional affidavit.
Yes, yes. In the meantime, the learned counsel for the petitioner in item 2 is granted liberty to file additional affidavit on the point urged before this court. Right? All right. Anything else? We'll hear everybody. Let's do it in a systematic manner.
Yes.
And once you finish your argument, if there is a short note, that will help us proceed with the judgment.
Only what it requests, that suppose we finished our argument, then the state will advance their argument.
Correct.
We'll have a chance of rebuttal.
Of course.
Then rebuttal,
Not rebuttal, reply.
a reply or rebuttal.
Yes.
Yes,
You have it.
then the notes which whether your lordship, after hearing of pointer, we can give a pointer, thereafter we can give a written notes.
No, that's not required. We want to know what are your basic arguments.
So pointer.
Pointers.
Actually, it is, I don't know whether it is in the file. Last time when we argued, so it was given, note was given to the court. I don't know about the other council, because all council has, I think, has given a note when it was heard before division bench, if I am not wrong.
We have-
We
Okay,
have given a note. We can give again, there is a,
Can you ask your junior to give it once again?
Yes, we can give it. There is no
So
problem.
whatever I have argued, I will give it. So that is the first compliment of the
Yes,
note.
yes,
And then ultimate note.
yes. So
will be
that we can
I
start
understand.
preparing a draft.
Part one,
The only idea.
part one of the note.
Yes, yes. Mr. Goswami, 10:15.
Cannot be 10:30.
Unless you want it to be changed.